Hi everyone, welcome. In this video, we will be discussing the first section from chapter 3 that is about the different kinds of obligations. But before that, let me introduce first myself. I am Jericho F. Corrada and my partner in this discussion, Mr. Josh Aldrin. So section 1, pure and conditional obligations, that is article 1179 to 1192. So it is stated from the article 1179 that every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. Every obligation which contains a resolutory condition shall also be demandable without prejudice to the effects of the happening of the event. So, the first sentence actually talks about pure obligations. So, this is an obligation that is demandable at once. So, because the performance has no condition and no term or period. So, for example, Miss Angel promised to deliver his specific car to Mr. Kester. So immediately, because there is no condition and no specific date for its fulfillment, therefore this is immediately demandable. So now, in contrast from the pure obligation is the conditional obligations. So what is conditional obligation? So to better understand, conditional obligation is an obligation where the acquisitions of rights as well as the extinguishment or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. So I guess you already know the meaning of condition, but in law, condition defines as every future event and uncertain event upon which an obligation is made to depend. So it is a future and a certain event which upon the acquisition or resolution of rights is made to depend by those who execute the juridical act. So always remember that in conditional obligation, effectivity is subject to the fulfillment of the condition. So these conditions must be future and uncertain event. But take note that the condition may also refer to past event unknown to the parties. So why must the event is uncertain if the condition is future event? It is because if it is certain, it is not already conditional obligation. Instead, it becomes obligation with a term or period. So there are two principal kinds of condition, the suspensive condition and resolutory condition. So suspensive condition. The fulfillment of the condition results in the acquisition of rights arising out of the obligation. Jurisprudence teaches us that when a contract is subject to a suspensive condition, its birth or effectivity can take place only if and when the event which constitutes the condition happens or is fulfilled. And if the suspensive condition does not take place, the parties would stand as if the conditional obligation has never existed. So, for example, X bound himself to deliver his only car to his son Y if the latter will pass all his enrolled subjects this semester. So thus, if the latter will pass all his subjects, X is obligated to deliver his only car to him. Another condition is the resolutory condition. This is the fulfillment of the condition results in extinguishments of rights arising out of the obligation. For example, X gave his only car to his son Y with the agreement that the latter will return his said car if he fails the certified public accountant board examination. Thus, the obligation is immediately demandable. However, if Y fails the said examination, he must return the car because the happening of the condition extinguishes the obligation of X. So now, when is the obligation demandable at once? So obviously, we already discussed it earlier from the article 1179 that it is demandable at once when it is a pure obligation. Also, every obligation which contains a resolutory condition shall also be demandable. So same si dya sa pure obligation which is demandable at once. Ang resolutory laman is without prejudice to the effects of the happening of the event. Because kung mahitabo si condition, the obligation will be extinguished. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period subject to the provision of Article 1197. So first, let's discuss the obligation with a period. So as said, pag obligation with a period, it is future and certain. Pag conditional obligation, it is future and uncertain. So when the debtor said that I will pay you when my means permit me to do so, that means that it is a condition with a period. So when is the obligation demandable? So kanus magde-demand si creditor. So ang right ni creditor is mato siya sa court, then let the court fix the date for the payment. So once ma-fix na sa court ang date for the payment, then on that given date, the obligation will be demandable. So Article 1181, in the conditional obligations, the acquisition of rights as well as the extinguishment or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. So in this article, it explains the suspensive condition and resolutory condition. So in the previous discussion, we already discussed the difference between the suspensive and resolutory condition. Which, if it tells the acquisition of rights, it means the suspensive condition. While if it is the extinguishment or loss of those already acquired, it means it is a resolutory condition. So as simple as that. So di na nato lison. So now let's proceed to the next article. Okay, so Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. So if it depends upon the chance or upon the will of the third person, the obligation shall take effect in conformity with the provision of this code. So here, we will understand protestative obligation, casual, and mixed obligation. So when the fulfillment of the condition depends upon the sole will of the debtor, this is a protestative obligation. So ang giingon, pag protestative obligation, nakadepende sa sole will ni debtor, it is void. Why effect? So take note sa word ng fulfillment, it means sa suspensive condition siya applicable. So hence, pag resolutory condition, bisan pag nakadepende siya sa will ni debtor, it is still valid. Di siya void. So always remember that if it is protestative on the side of the debtor and suspensive condition, it is void. While if it is protestative on the side of the debtor and resolutory condition siya, it is valid or acceptable. So if it is also protestative on the part of the creditor, still it is valid. For example, if I'll give you 10,000 pesos if you like, so ikaw ang mo decide. So ingon ng law, valid na siya. So now, if the condition is casual, one which depends exclusively upon chance, pag ingon ana, valid kuno na, ingon ang law. So if it is also mixed, it depends upon chance or upon the will of a third person, it is valid. Article 1183 states that impossible conditions, those contrary to good customs or public policy, and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. So the condition not to do an impossible thing shall be considered as not having been agreed upon. So in this article, this tackles about impossible conditions. So there are different kinds of impossible conditions. The physical impossible condition and the legal impossible conditions. The physical impossible condition are conditions which are contrary to the law of nature. So like for example, X obliged himself to give Y his only house and lot if Y can make a flying study table. We all know that a flying study table is impossible to be made. And another is the legal impossible condition. These conditions These are conditions which are contrary to law, morals, good customs, public order, or public policy. It means it is prohibited by law. Like for example, X promised to pay 100,000 if Y kill Pedro. So killing someone is prohibited by law. So always remember the general rule. Impossible conditions annul the obligation which depends upon them. Consequently, both the condition and the obligation are void. But there is an exception. It is stated from the Article 1183 that indivisible obligation, that part thereof which is not affected by the impossible or unlawful condition, shall be valid. So, unsa man din ang divisible obligation? Divisible obligations are those which have as their object as prestation which is susceptible of partial performance without the essence of the obligation being changed. Like for example, if X promised to pay Y 10,000 if Y will achieve the high score in their basketball game today, and additional 5,000 if Y can inflict serious physical injuries to their opponent Z. So the first condition does not contradict the law, morals, good customs, public order, or public policy, and it is possible. While the second condition is a legal possible condition. That's why it is void. Okay, so let's now proceed to Article 1184. So it is stated from 1184 that a condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. So this article talks about the positive condition where the happening of the event at a determinate time shall extinguish the obligation as soon as the time expires. For example, I will give you 100,000 if you marry Maria this year. Pero nahuman na laman ang year, paghihapon nimo si Japa kasli. So may obligation to pay you 100,000 will be extinguished. Or if it has become indubitable that the event will not take place. For example, panahuman ang karon nga year but si Maria namatay. So it is impossible to marry Maria since namatay na si Ja. So my obligation to pay you 100,000 will also be extinguished. So let's now proceed to Article 1185. So in Article 1185, it is stated that the condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. So, sa kaning article about si just a negative condition. So, kabaliktaran si from Article 1184 which talks or tackle about positive condition. So, for example, in a scenario when the time indicated has elapsed. For example, if the obligation is I will promise to pay you 100,000 if you will not marry Maria this year. So if January 1 na, so it means pa mo napakasan si Maria, that means you already fulfilled your obligation. That's why I am also obliged to pay you 100,000. So another is, or if it has become evident that the event cannot occur. For example, si Maria namatay karon nga year, same as the year in the contract. So it is impossible to marry Maria. So I am already obliged to pay you 100,000. Another scenario is if no time has been fixed. So kung why time naka-indicate sa contracts, the court will consider the intention of the parties kung unsa man gani ang period ang intended sa parties.
So to continue on, I will be the one to report from Article 1186 up to Article 1192. So to start with, the Article 1186, it says here that the condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. So, the above stated article refers to the doctrine of constructive fulfillment of suspensive condition. So, the requisites of the doctrine of constructive fulfillment of a suspensive condition is the intent of the obligor to prevent the fulfillment of the condition and the actual prevention of the fulfillment. So, here's a problem for us to understand more of this, more of the article. So, these sold 3 parcels of land with improvements to O, as these properties were mortgaged to Z Incorporated, and D and O executed an authorized deed of absolute sale with assumption of mortgage stating. So here's the statement that for and in consideration of the sum of 1.1 million pesos, the receipt whereof is hereby acknowledged from O to the entire satisfaction of D. Said D hereby sell, transfer, and convey in a manner of absolute and irrevocable unto said O. He hires and assigns that certain real estate together with the buildings and other improvements existing thereon under the following terms and conditions. So, that upon full payment of O, the amount of 415,500 pesos, D shall execute and sign a deed of assumption of mortgage in favor of O without any further cost whatsoever. That O shall assume payment of the outstanding loan of 684,500 pesos with Z Incorporated. So, to explain this, pursuant to this deed, O gave D 415,500 pesos as initial payment. D, on the other hand, handed the keys to the property and wrote a letter to informing Z Incorporated of the sale, authorizing it to accept payment from O and release certificates of title. Subsequently, O learned that D again sold the same properties to X and changed the locks, rendering the keys he gave her useless. O thus proceeded to Z Incorporated to inquire about the credit investigations. However, she was informed that D had already paid the amount due and had taken back the certificates of title. O filed a complaint for a specific performance declaration of nullity of the second sale against D and X. D claimed that since the transaction was subject to a condition, they only entered into a contract to sell. Inasmuch as O did apply for a loan from Z Incorporated, the condition did not arise. Consequently, the sale was not perfected and he could freely dispose of the properties. So, is Article 1186 of the Civil Code applicable? So, to answer this, assuming arguendo that the agreement of the parties was subject to the condition that Z Incorporated had to approve the assumption of mortgage. The said condition was considered fulfilled as D prevented its fulfillment by paying his outstanding obligation and taking back the certificates of title without even notifying O. In this connection, Article 1186 of the Civil Code provides the condition that shall be fulfilled when the obligor voluntarily prevents its fulfillment. So, it is applicable. So, let's jump into Article 1187. It says here that the effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received, unless from the nature and circumstance of the obligation it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the court shall determine each case. The retroactive effect of the condition shall be the retroactive effect of the condition that has been complied with. So the principle here's the principle of retroactivity in suspensive condition. It is limited only to the effects of the obligation. So number one is in obligation to give, and number two is in obligation to do or not to do. So in number one, in obligation not to give, once the condition has been fulfilled, it shall retroact to the day of the constitution of the obligation. The condition is only accidental element of the contract. Hence, the obligation is still valid even in the absence of such condition. So, to give an example, on December 29, 2000, Toll Regulatory Board or TRB filed a complaint for expropriation against landowners whose properties would be affected by the construction, rehabilitation, and expansion of the North Luzon Expressway. H Corp was one of the affected landowners. On March 18, 2002, TRB manifested that it deposited the total of 28,406,700 pesos with the Land Bank of the Philippines. On March 3, 2003, H Corp filed a motion to withdraw deposit, praying that it would be allowed to withdraw with the amount of 22,968,000 pesos out of TRB's advance deposit of the said amount earlier with the Land Bank of the Philippines, including the interest which accrued thereon. Acting on said motion, the RTC issued an order dated April 21, 2003, directing the manager of LBP or Land Bank of the Philippines to release in favor of H Corp the amount of 22,968,000 pesos since the latter already proved its absolute ownership over the subject properties and the paid taxes due thereon to the government. So would the interest earned by deposited amount in the expropriation account accrue to the H Corp by virtue of accession? So to answer that, notwithstanding that the amount was deposited under the DPWH account, ownership over the deposit transferred by operation of law to H Corp, and whatever interest considered as its civil proofs accruing to the amount of 22,968,000 pesos, 22 million, so should properly pertain to H Corp as the lawful owner to the principal amount deposited following the principle of accession. Bank interest partake the nature of civil proofs under the Article 442 of the new Civil Code, and since these are considered first ownership thereof should be due to the owner principal, undoubtedly being an attribute to the ownership. H Corp's right over the fruits, that is the bank interest, must be respected. So, in number 2, in obligation to do or not to do, here are two retroactive effects as to the fruits and interest in obligation to give. So, number 1 is reciprocal obligation. So, in this obligation, there is no retroactive effect. The fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. And in number 2, in unilateral obligation, there is no retroactive effect also. The debtor shall appropriate the fruits and interest received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. So to continue on, here is Article 188. So it says here that the creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of suspensive condition. So here are the rights of the creditor and the debtor before the fulfillment of the condition. So here's the rights of the creditor. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. And so here is also the rights of the debtor. So the debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. If the debtor paid with knowledge of the condition and not by mistake, he impliedly waives the condition. Therefore, he cannot recover. So here's an example to give us more knowledge about this article. So spouses H and W allege in their complaint that Y sold to them the eastern portion of her property. So the memorandum of agreement stated that the purchase price of 19,042 pesos shall be paid as follows. So the amount 1,000 in the concept of earnest money upon execution of the said instrument, and B, the balance thereof in the amount of 18,042 pesos within 6 months from the date of the vendees and notified by the vendor of the fact that the certificate of title to the eastern portion of the vendor's lot is ready for transfer in the names of the vendees. It was also agreed that the title to ownership, possession, and enjoyment of the portions sold shall remain with the vendor until the full consideration of the sale shall have been received by her and acknowledged in a document duly executed for said purpose. Expenses for the registration of the lot shall be borne by the parties, share and share alike. However, it shall be the vendor who must initiate the filing of the necessary petition in the proper court. So spouses as vendees paid Y the earnest money of 1,000 pesos. Subsequently, Y and as H for additional sums of money totaling to 2,774 pesos duly received as part payment of the subject lot. So Y filed a petition for the registration of title to land consisting of 29,532 square meters, including the portion sold to the spouses. The spouses allege that Y maliciously executed a deed of absolute sale of the whole parcel of land, which included the portion already sold to them. To spouses M and N, who had previous knowledge of the sale to them, the spouses also allege that the spouses M and N, by means of fraud, were able to secure a title to the entire property, including the eastern portion previously sold to them. Are the spouses H and W allowed to recover what they have paid in expectancy that the condition would happen? So here's the answer. From the memorandum of agreement, it appears that the agreement was in the nature of contract to sell, as the vendor Y clearly reserved to herself ownership and possession of the property until full payment of the purchase price by the vendees. Such payment is being a possessive suspensive condition, the failure of which is not considered a breach, casual or serious, but imply an event which prevented the obligation from acquiring obligatory force. However, under the second paragraph of Article 188, the new civil code, even in the spouses did not mistakenly make partial payments. Inasmuch as the suspensive condition was not fulfilled, it is only fair and just that the spouses be allowed to recover what they had paid in expectancy that the condition would happen. Otherwise, there would be unjust enrichment on the part of Y. Hence, Y should return the sum of 3,774 pesos received from the spouses, H and W, with interest of 12% per annum. So that's the answer to the problem. So let's move on to Article 1189. So when the condition have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in the case of improvement, loss, or deterioration of the thing during the pendency of the condition. So if the thing is lost without the fault of the debtor, the obligation shall be extinguished. If the thing is lost through the fault of the debtor, he shall be obligated to pay damages. It is understood that the thing is lost when it perishes or goes out of commerce, or dispersed in such a way that its existence is unknown and it cannot be recovered. So when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. It is if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with indemnity for damages in either case. And if the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. And lastly, if it if it is improved at the expense of the debtor, he shall have no other right than the granted to the usufructuary. So here is to explain the loss. So a thing is lost when it perishes, goes out of commerce, or disappears in such a way that its existence is unknown and it cannot be recovered. So it is like, it's just, it's just common sense that it is lost when it's lost. So to proceed, rules in case of loss, deterioration of or improvement of a thing pending that the happening of the condition in obligation to give. So number one, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. So here's an example. X obliged himself to deliver his only car to Y if the latter passes his board examination. However, before the release of the result of the board examination, said car was lost through an earthquake. Note that the car was lost through fortuitous event, thus obligation is extinguished. So number two, if the thing is lost through fault of the debtor shall be obliged to pay the damages. So here's an example. X obliged himself to deliver his only car to Y if Y graduates. However, before the date of graduation, said car was totally destroyed when it fell in a ravine while X was driving it. The result of the police investigation showed that X was drunk when the incident happened. Consequently, X is liable for the damages because of drunk driving is an act of fault or negligence. So number three, when the thing deteriorates without the fault of the debtor, the impairment is borne by the creditor. So here's an example. X bound himself to give Y his only car if the latter passes his subject obligations and contracts this second semester. Subsequently, after 4 months from the start of the semester, Y passed the said subject. Naturally, a car deteriorates through wear and tear. The question now is who will bear the decrease in value of the car or its depreciation after 4 months? The answer is Y, because the depreciation is without the fault of X, because it is the time passes. So the deterioration is a normal thing. So number 4, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with indemnity for the damages of the case. So here's an example. On February 14, 2020, X bound himself to sell his only car to Y if the latter passes the April 2020 Career Service Professional Examination. Y passed the said government examination. However, from February 14, 2020 up to April 2020, X used the car negligently by choosing to pass through the rough and gravel roads instead of passing through the cemented roads. In this case, Y can choose the specific performance or in the alternative rescission in indemnity for the damages in either case. So in number 5, if the thing is improved by its nature or time, the improvement shall inure to the benefit of the creditor. So here's an example. On May 1, 2019, X bound himself to give his only parcel to the land of Y if latter passes the 2020 Career Service Professional Examination. So Y passed the said government examination. A land normally increases in value through the passage of time. Thus, in present case, the improvement shall inure to the benefit of Y. So to number 6, if it's improved at the expense of the debtor shall have no other right than the granted to the usufructuary. So here's an example. So on February 14, 2020, X bound himself to give his only car to Y if the latter passes the government examination. So the Y passed the government examination. However, from February 14 up to April 2020, X introduced improvement on the said car, like the repainting of the entire body of the car because of deterioration, change of the major parts of its engine because of the leakage of oil, and putting pink leather cover in the seats. In the above case, X will exercise the right of usufructuary, hence he can remove the leather cover of the seats. Also, he has the right to indemnify on his expenses in the repaint of the car and the change of major parts of the engine, as these are necessary expenses. Corollary, if X made the damage to the car like scratches therein, he may set off any of these damages against the improvements. So here the usufruct explained. So usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law otherwise provides. So to continue on, here is Article 1190. When the conditions have for their purpose in the extinguishment of an obligation to give, the parties, upon the fulfillment of said condition, shall return to each other what they have received. So it also says here that in case of the loss, deterioration of or improvement of the thing, the provision which with respect to the debtor are laid down, and the preceding article shall be applied to the party who is bound to return. As for the obligation and to do or not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards to the effect of the extinguishment of the obligations. So the effect of fulfillment of resolutory condition in obligation to give, the parties upon the fulfillment of the said conditions shall return to each other what they have received. And the effect of fulfillment of resolutory condition in obligation to do and not to do, in obligation to do and not to do, the court shall determine, in each case, the retroactive effect of the condition that has been complied with. So here's a problem for us to understand more about this article. So the heirs of X and Y are the successors in interest of the former registered owners of two parcels of land situating in Lahog, Cebu City, designated as lot number 916 and lot number 920. In the 1949, the National Airport Corporation, as the predecessor of Agency of Mactan Cebu International Airport Authority, wanted to acquire the lot numbers 116 and 916 and 920 rather, above described among the two other parcels of the land for the proposed expansion of the Lahog Airport to entice the landowners to cede their properties. The government assured them that they could repurchase their lands once Lahog Airport was closed or its operation transferred to the Mactan Airport. Some of the landowners executed deeds of sale with the right of repurchase in favor of the government, but many others, including the owners of numbers 916 and 920 herein mentioned, refused the offer because the payment was perceived to be way below the market price. So, the National Airport Corporation filed a complaint for the expropriation of lots number 916 and 920 and other subject realities. So to answer that, in the case of the bar, the heirs conveyed lots number 916 and 922 to the government, with the latter obliging itself to use the realities for the expansion of the Lahog Airport. Failing to keep its bargain, the government can be compelled by the heirs to convey the parcel land to them. Otherwise, the heirs would be denied the use of their properties upon the state of affairs that was not conceived or completed when the expropriation was authorized. The rights and obligation between the constructive trustee and beneficiary, in this case MCIAA or Mactan Cebu International Airport Authorities, and the heirs of over lots number 16 and 920 are echoed in Article 1190 of the Civil Code. When the conditions have for the purpose of the extinguishment of an obligation to give, the parties upon the fulfillment of said condition shall return to each other what they have fulfilled, and said to condition shall return to other what they have received. In case of the loss, deterioration, and improvement of the thing, the provisions which with respect to the debtor are laid down in preceding article shall be applied to the party who is bound to return. So let's continue on to Article 1191. So it says here that the power to rescind obligations is implied in reciprocal ones. In case of the obligors should not comply with what is incumbent upon him, the injured party may choose between the fulfillment and the rescission of the obligation with the payment of damages in either case. He may also seek rescission even after he has chosen fulfillment if the latter should become impossible. The court shall decree the rescission claim unless there be just cause authorizing the fixing of a period that is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with Articles 1385 and 1388 and the mortgage law. So it also states here that rescission or resolution under Article 1191 is predicated on the failure of one party's in reciprocal obligation to fulfill the prestation as required by that obligation it is not based on violation of consent through fraudulent misrepresentation. So what is rescission? So it says here that the rescission has the effect of unmaking a contract or its undoing from the beginning, and not merely its termination. Hence, rescission creates the obligation to return the object to the contract. It can be carried out only when the one who demands rescission can return whatever he may be obliged to restore. To rescind is to declare a contract void at its inception and to put an end to it as though it never was. It is merely not to terminate it and release the parties from the further obligation to each other, but appropriate it from the beginning and restore the parties to their relation position as if no contract have been made. So what is mutual restitution? So mutual restitution is required in cases revolving rescission under Article 1191. This means bringing the parties back to their original status prior to the inception of the contract. Article 1385 of the Civil Code provides the effects of rescission to it. So rescission creates the obligation to return the things which were the object of the contract together with their fruit and the price of with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may oblige to restore. So neither shall rescission take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. In this case, indemnity of damages may be demanded from the person causing the loss. This court has consistently ruled that this provision applies to rescission under Article 1191. So let's proceed to what is extrajudicial rescission. So extrajudicial rescission of a contract is not possible without an express stipulation of that effect. So here's an alternative remedies of injured party. So fulfillment of the obligation with damages. So this refers to specific performance. So what is specific performance? Black's Law Dictionary defines specific performance as the remedy of requiring exact performance of a contract in the specific form in which it was made, or according to the precise terms agreed upon, the actual accomplishment of a contract by a party bound to fulfill it. So, number 2, rescission of the obligation with damages. So, even after the injured party was chosen fulfillment and such fulfillment should become impossible, he can still seek the rescission of the obligation. So, number 2, rescission of the obligation with damages. So, even after the injured party was chosen fulfillment and such fulfillment should become impossible, he can still seek the rescission of the obligation. So let's jump to Article 1192. So it says here that in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered of the courts if it cannot be determined of which of the parties first violated the contract. The same shall be extinguished, and each shall bear its own damages. So effects of breach by both parties. Number one is the liability of the first infractor shall be equitably tempered by the courts. Number two, if it cannot be determined of which of the parties first violated the contract, the same shall be extinguished, and each shall bear his own damages. So here's an example for us to understand more about this article. So on January 2, 1995, X, an architect contractor, entered into an owner-contractor agreement with Y for the construction of a proposed boutique owned by the latter. The agreement provides that in the consideration of the sum of 200,000 pesos, the contractor agrees to the furnish of labor, tools, and equipment to complete the work on the boutique as per specification within 45 days, excluding Sundays from the date of delivery of the construction materials. Payment by the owner shall be made by progress billing to the collected every 2 weeks based on the accomplishment of the work value submitted by the contractor to the owner as certified for the payment by the architect assigned on site. So for work accomplished during the period January 19 to 28, 1995, X submitted and was paid his progress billing number 1. Partial billing numbers 2 and 3 respectively were likewise made and paid. So when X submitted the fourth progress billing on March 31, 1995 for the period covering March 4 to 18, 1995 in the sum of 30,950 pesos equivalent to 15%, 0.47% of the actual job, Y refused to pay the same. X abandoned the project on April 24, 1995 when it became apparent that he could complete the canzo flooring on the date agreed upon. So, due to Y's continued refusal to pay X's fourth progress billing despite written demands from his counsel, the latter was constrained to file an action for the sum of money with damages. What is the legal effect where both parties have committed breach of their respective obligations? So, to answer that, considering that both parties committed a breach of their respective obligation, Article 1192 of the Civil Code is in all force. Under this provision, the second infractor is not liable for damages at all. The damages for the second breach, which would have been payable by the second infractor to the first infractor, being compensated instead by the mitigation of the first infractor's liability for damages arising from his earlier breach. The first infractor, on the other hand, is liable for damages, but the same shall equitably tempered by the courts, since the second infractor also derived and or thought he would derive some advantage by his own act or neglect. The Article 2215, however, seems contradictory as it gives the court option whether or not to equitably mitigate the damages and does not take into account which infractor first committed breach. So the Article 2215 says that in contracts, quasi-contracts, and quasi-delicts, the court may equitably mitigate the damages under circumstances other than the case referred to in the preceding article, as in following instances. So in Articles 1192 and 2215 of the Civil Code are not irreconcilably conflicting. The plaintiff referred to in Article 2215 should be deemed to be the second infractor, while the one whose liability for damages may be mitigated is the first infractor. Furthermore, the directions to equitably tempered the liability of the first infractor in Articles 1192 and 2215 are both subject to the discretion of the court, despite the word shall in Article 1192, in the sense that is for the courts to decide what is equitable for under the circumstances. So, in the case at bar, both X and Y claim that it was the other party who first committed a breach of contract obligation, considering this court's finding that there had been no contract novation required to finish the Kenzo flooring before the fourth progress billing that is paid. It is crystal clear that it was Y who first violated the contract, and as such, it is Y who is liable to pay damages, which may, however, is reduced, depending on what is equitable under the circumstances. On the other hand, since X is the second infractor, he is not liable to pay damages in Y's counterclaim. That is all. Thank you.